Hello once again, and Dean Tong here. On behalf of Families Divided TV, this is my final presentation for Families Access Fighting for Children's Rights.com. I want to thank Elaine Cobb for having me. These presentations have been very enjoyable for me, and hopefully you all have gleaned some information that you can use in your own cases. Whether you're pro se or back in court for your attorneys. This presentation here is basically false allegations navigating the three-ring circus. And so what do I mean by the three-ring circus? Obviously, I'm not talking about Ringling Brothers Barnum and Bailey Circus, but you could make that correlation possibly when you get into court. So I'm talking about mainly you've been arrested, you have a criminal case, say, for example, state of Florida versus Dean Tong. You have a juvenile dependency case. CPS has filed a petition against you under Florida statute chapter 39 or whatever your dependency and neglect statute is in your state. Basically, CPS is trying to get a judge to adjudicate the child dependent, which means the child has been abused, neglected, or abandoned by you, the accused, in juvenile court. The consequence of that court, obviously, is potentially termination of your parental rights. In criminal court, obviously, in most of my cases, as an expert in child sex abuse cases nationally, you're facing a felony conviction, you're facing prison time, perhaps life in prison, as it is in my state of Florida, and or sex offender registration if and when you get out of prison. And of course, the other court being family court, petitioner versus respondent. Obviously, in this court, we see a lot of parental alienation cases. We can see parental alienation cases in other courts as well, other jurisdictions. I'll get into that later on during this presentation. But so the first hurdle, whenever you're fighting the three-ring circus, and that three-ring circus could also include the state CPS placing your name on the child abuse registry, okay, where basically, they're accusing you of alleged abuse or neglect. And let's say you're a professional, you're a doctor, you're a nurse, you're a therapist, you're a youth care worker. It's going to terminate your occupation unless you successfully get CPS to redact that finding. That's going to require an administrative law judge to hear a appeal proceeding later on during that case. That's a civil matter, just like family court, just like injunction, just like dependency, TPR, termination of parental rights. Placing the name on the child abuse registry is a civil proceeding. The burden of proof is 51%, a preponderance of evidence where CPS has to prove their case to basically place your name on the child abuse registry. My state of Florida does not have any child abuse registry anymore, so that that was a while ago. The other court potentially, as part of the three-ring circus, could be ex parte motion and relief based on an injunction or restraining order, just based on mere allegations, a statement of fear, threat, and bodily harm under VAWA, the Violence Against Women Act, from 30 years ago, 1994. Or sexual abuse or physical abuse and or whatever the complaining witness is basically authoring in his or her petition affidavit for protection from abuse. So this is what I mean by the three-ring circus. You're basically litigating in court, family court, juvenile court, criminal court at the same time, all three jurisdictions. So your very first objective here is to seek out counsel. Obviously, anything you say can and will be used against you in a court of law. I don't advise you to speak to any CPS agent, any detective, any officer, any investigator without counsel present. If you do, you can be committing legal suicide. So please don't do that. All right. These are not your friends. This is Big Brother, Uncle Sam, the government. Their mindset is children don't lie. Children are not mistaken about sexual assault, physical assault, even if there's no medical findings, which usually there aren't. They must be believed and protected at all costs. This is the operating maxim of the government. Okay. So if this is a tennis match, advantage government, not you, the accused. You, the accused, are presumed guilty. You, the accused, have to prove a negative to prove your innocence. That's how this works, unfortunately. My website, abuse-excuse.com, has been up on the internet for almost 30 years now, since 1997. All three of my books have been published now for over 20 years, the most recent being The Elusive Innocence, which it's in its seventh or eighth printing now, published back in 2002, some 22 years ago. That book is still used by lawyers today as a handbook for those falsely accused in court. All right, so seeking counsel. This is not rocket science, but there is an art and science to choosing the right lawyer. You want to make sure your lawyer is board certified in whatever legal genre of law you're going to be hiring that lawyer in. Board certified, family law, juvenile law, criminal law. Good luck in finding one who's competent and board certified in all three legal genres. Chances are you may wind up having to retain multiple attorneys. Obviously, that can be very expensive. Those lawyers need to communicate with each other. They need to work in concert. They need to be on the same page. All I's dotted and T's crossed, because there are some discovery items that can be obtained in the civil proceedings that you may not be able to do in the criminal case, but yet can help the criminal defense attorney to help prove that negative and exonerate you if, in fact, you have been wrongly accused. Obviously, I do want to precede this by saying that abuse does happen, right? So physical abuse, sexual abuse does happen. Physical abuse much, much more so than sexual abuse. Recent study conducted by Dr. David Finkelhor from the National Crime Information Laboratory, Durham, New Hampshire, from 1990 to 2022. Recent study just published this year in child maltreatment. 63% decrease in the incidence of child sexual assault over the last 30 years. So think about that. 63% decrease in the incidence of child sexual assault. So what does that tell you? It tells you that there are many, many more unsubstantiated and some false cases than there are confirmed and bona fide cases out there. And so most cases are not false. Only about 5, maybe 9% are false, which by definition is malice aforethought, premeditation, and bad faith. I'm going to pick up the phone. I'm going to call 1-800-96-ABUSE, which is our Florida toll-free hotline number, and I'm going to ruin your life in a New York minute by making that call. We're in a divorce, we're in a custody battle, we're in a parenting time dispute, and I'm going to wield that child as a pawn, weapon, or tool and just accuse you based on hearsay. And all of a sudden, there's a knock on your door from the government. Miss Sally Jones is there. Officer Rembert is there. And they are there to do a minimal facts interview with your kid. Like I said, don't speak to the government without counsel present. So you have to be diplomatic with these people. You have to be kind. You have to be polite. Leave your card. I'll get back to you. Obviously, you've got to retain counsel. So very, very important, right? I'm an expert, but I'm not a lawyer. Your very first professional that you must hire in any one of these cases, this three-ring circus, case you're involved in, is a competent attorney or attorneys. And if you cannot afford counsel, if you're in that CPS juvenile court and or state versus you, the accused offender criminal court, you can complete a financial affidavit to basically try to get a judge to declare you indigent. In forma pauperis is the legal Latin phrase meaning you're poor, you don't have enough resources for that $20,000 or $25,000 attorney for your criminal case, for your juvenile case. Family court, you get as much justice as you can afford. Unfortunately, you're not entitled to a free pro bono attorney in family court. So you'd have to do that one pro se if you cannot afford counsel. But the other two cases, You can get a lawyer for free, public defender, court-appointed counsel, and you can get my services for free as an expert. I am linked up to justiceadmin.org, which is a website that basically is held by the Justice Administrative Commission in Tallahassee, Florida, our capital. I've been with them for 15 years. Likewise, Maricopa County, Phoenix, Arizona, been with them for 15 years, OPDS, Office of Public Defense Services. And so these jurisdictions, other jurisdictions, I've been authorized and approved by judges in criminal and or juvenile court, where they're trying to throw you in prison, evict you of felony, make you go through sex offender registration, take your kids, terminate your rights. I can help you, but you have to be declared indigent. You have to fill out that financial affidavit with your attorney, submit it to the court. Then the lawyer files a motion for expert fees, basically attaching my CV, which is my professional resume, as Exhibit A to that pleading. And there'll be a hearing on that matter. And hopefully the judge will find you indigent, the accused offender, and you're able to start running forward with counsel and your expert. Obviously, there are a lot of PhDs and MDs out there who do the work I do in America. And so I'm not the only expert out there, but make sure you do your due diligence. Make sure you conduct a proper vetting procedure for counsel. So you want to, there's a section in my book, Elusive Innocence, at my website, abuse-excuse.com, how to choose your attorney. Okay, that same appendix, that same section in my website, appendix in the book, how to choose your attorney, is there for you to guide you in a blow-by-blow, play-by-play guidebook, if you will, on how to basically select the right lawyer. Go to avvo.com, avvo.com is your #1 legal review website for attorneys. Okay, you want to make sure the lawyer, like I said, board certified, possibly AV rated, Martindale Hubbell, and basically, no lawyer is going to give you their client list like I do at my testimonial page at my website. Okay, where you can reach out and talk to people who I've helped over the decades at my website. No lawyer is going to provide you a attorney-client privilege list. They will tell you, yes, I've worked these cases. Yes, I've won these cases. You have to trust them. You have to basically go off their track record, their AVO reviews, have a free consultation with them, a come to Jesus meeting in person, over the phone, if you will, to see if there's chemistry there. Is this lawyer the right fit? Is this lawyer willing to work with an expert, perhaps down the road, if not immediately? Can the expert and yourself, the accused, and the lawyer work as the three musketeers? Very, very, very important to be able to work as a team. Okay. There are no lone rangers here. So the lawyer has to basically know the rules of procedure for the jurisdiction that the lawyer is litigating in. So we have criminal rules of procedure. We have juvenile rules of procedure. We have family law rules of procedure in my state of Florida. We also have civil rules of procedure. So in my state of Florida, we have the civil rules of procedure and family law rules of procedure, both governing family law cases under Chapter 61 and Florida Statute Chapter 61.13, which is the best interest of the child and best interest analysis factors that a judge must conduct in Florida to basically glean which parent should receive more time sharing than the other. Custody was eradicated from the statutory language in my state of Florida in 2008. It is no longer called visitation to custody. It's called time sharing. So basically, one litigant is going to have more time sharing than the other with the child, with the children, based on 20 factors that the court must go through. For example, which parent better fosters and nurtures the child with the other parent, perhaps which parent is alienating, denigrating, disparaging, vilifying the other parent in front of the child, And so all these factors come into play. Obviously, child abuse, child neglect, child abandonment, which come under the dependency case, juvenile rules of procedure, and juvenile court and law is a very compelling factor the court must look at. So, if you are confirmed or substantiated by Child Protective Services, and you're put on the child abuse registry, and or you have that dependency petition, that TPR petition filed against you, again, termination for parental rights of your parental rights, then they're making the allegations, right? CPS agent or CPI, as it's called in my state of Florida, Child Protective Investigator, is making the allegations. You have to disprove those allegations. You have to impeach rather the state's case in chief. And their allegations. In this instance, the government, Child Protective Services, they are going to be represented by counsel. The judge will appoint a guardian ad litem in that case on behalf of the allegedly abused child, allegedly neglected child or children. The judge will appoint a GAL. That's a lawyer that, from a guy who's got 3 decades of professional experience, I can tell you, is most likely going to be against you, the accused, is most likely going to be on the side and to join the belief system of CPS, that you did it because the child possibly said you did it, touched your pee-pee, or punched the child in the face, or kicked the child in the ribs, and there may or may not be medical traumatic findings here. Only in 5% of cases, 1 in 20. This was a peer-reviewed study published in the Journal of the Medical Association, JAMA, a long time ago. 5% of cases contain medical traumatic findings, 1 in 20. So most cases, 95%, are going to be he said, she said, what a child said. The exception to the rule, child victim hearsay. Being the exception to the rule, makes the hearsay outcry or disclosure from a child legally admissible. Okay, it's why you can get put in handcuffs. It's why you can have a dependency petition filed against you. It's why mother in your case can file an ex parte petition against you, one-party communication without your knowledge, saying that the child told her you touched her pee-pee, the daughter's pee-pee, or the stepdaughter's pee-pee. All right. And so this is the exception to the hearsay rule, Rule 803, in my state of Florida, Florida Statute 90.803, parentheses 23, the 23rd exception of the hearsay rule is going to get you in court, I can assure you. The judge is going to make a mistake and err on the side of caution, on the side of the kid, on the side of the child very quickly here. Again, you're up against involved here in a Mike Tyson fight, having to prove that negative. And so, these allegations can come from anywhere, from children. Again, I'm not saying they haven't been sexually abused, but there are factors. There are 3 factors that govern the credibility of a child's outcry or disclosure. Now, your lawyer may or may not know this, and by God, I hope he or she does. But those 3 factors are based on case law, federal case law, Idaho v. Wright, WRIGHT, 1990. Okay, in my state of Florida, state of Florida versus Townsend, state of Florida versus Townsend, TOWNSEND, 1994 is the seminal case law governing the child's credibility, and those factors are: was the child's outcry or disclosure spontaneous? Does it contain an addition of reliability? Does it contain a particularized guarantee of trustworthiness? Okay, so spontaneity, reliability, trustworthiness. Those are the 3 factors that a judge has to decide on at a hearing to believe you, the accused, that you didn't do it, or that the child's outcry or disclosure is credible and that you did do it. The judge determines credibility. The judge under Rule 704 determines the ultimate issue at bar of whether you sexually assaulted and molested the kid or not. I cannot give an opinion on that. I can leave the horse to the water, and hopefully she or he will drink that water, but I cannot give that opinion of whether the child was abused or not, unless the judge gives me the green light when I'm on the stand under oath testifying as an expert to do so. In my career, which spans all 50 states, 70 times I've testified as an expert witness in 19 jurisdictions, soon to be 20. I'm going up against a psychologist in New Jersey here in a future hearing. It's called a Michaels hearing, named after Kelly Michaels. Kelly Michaels was the daycare teacher in New Jersey back in the late 80s, around 1988. She was convicted of molesting children in her care at her daycare. Kelly Michaels was. Her conviction was overturned by the Supreme Court some years later, and law developed from her reversal of her conviction called the Michaels or Taint hearing. Taint, whether the child's information, disclosure, outcry contains reliability and trustworthiness based on a spontaneous disclosure, or whether her information was adulterated, contaminated, or tainted. Okay, so there are factors. Those are very, very important factors that eventually will come to pass. And when you have your day in court, to basically face the music of what you're accused of. And let me tell you, these allegations, these other cases, collateral cases, I'll call them, criminal court, juvenile court, which obviously supersede family court. Juvenile supersedes family, criminal supersedes all of them, right? Your lawyers need to work together, because when your lawyer conducts discovery, which is, for example, motion to compel production of documents to get all the records from CPS, so the CPS intake reports, the guardian ad litem report, to see what that's all about, where the mindset of the GAL is, to basically get the anogenital rape exam report, if one was done, physical examination report, you got to get that. Obviously, the forensic interview, very, very crucial. It's what I'm naturally certified in as a defense expert, to review and critique that forensic interview of the child conducted on DVD, captured on DVD. I'll need to see that DVD or USB port or something electronically online that I can open up in a WMV file, so I can see the video audio of the child's forensic interview, where the interviewer will go over right from wrong, truth from lie, good touch from bad touch, from secret touch, the body parts, and get into the index allegations with said child victim. And so all this is important, because it can all be used potentially to help you if the results of the same do help you in the criminal case, right? And so to my knowledge, a substantiated finding against you, the accused, cannot be used against you in a criminal case. But for example, depositions, let's say you can't obtain depositions, which is basically you're going to a lawyer's office, or by Zoom, you're going to be questioned under oath. There'll be a court reporter, and you will be questioned. Basically, your credibility is going to try to be impeached as you be asked questions by an opposing lawyer, about what's going on with allegations. And so you can have that deposition typed up and transcribed and pay for the same to do so. And then if that deposition transcript is favorable to your legal position, you can furnish that to the criminal defense attorney, who then can ask the court to take judicial notice of that, or possibly even admit it as an exhibit into the criminal case. You have to check with the criminal rules of evidence with your attorney in the state you're in. All right, so there's a lot of moving parts here in these cases. Very, very complex. Everything happens very quickly, and then it slows down. The question is your lawyer going to play the let's wait and see what happens game and be reactive, or is your lawyer going to think like I do, unconventionally, outside the box, and be proactive and try to help do things that can help basically prove that negative sooner than later. Obviously, if the child's in an atmosphere of being alienated against you, where parental gatekeeping may be happening, coercive control may be happening, parental alienation may be happening, which, of course, as we all know, is mental, emotional, psychological child abuse in and of itself, then that's just going to pour gasoline on a fire for the child to basically, the child's recognition memory is going to kick in. All these bad allegations that have been made against you possibly will be heard and believed, reinforced by the child, and the child may be in therapy to reinforce the same. In my state of Florida, it's called SATP, Sexual Abuse Treatment Program, where the therapist may be doing de novo therapy, but it's supposed to be doing de novo therapy, but actually be doing de facto therapy in a de novo case. In other words, a case that has the merits of the case have not yet been litigated or tried or heard in a court of law, but the therapist is treating the kid as a victim of trauma by you, the accused, because the therapist is not being open-minded. So the origin, the source of the child's allegations and what the child is telling the therapist is that, daddy touched my pee-pee, for example. But let's say CPS has not confirmed that yet. The therapist hasn't heard back from CPT, which is what it's called in my state of Florida, who conducts the child forensic interviews. No judge has made a finding of fact, conclusion of law that the child is a victim of sexual abuse perpetrated by Mr. Jones or Mr. Smith, the accused. So, but the therapist is treating the kid with TFCBT, trauma-focused cognitive behavioral therapy, or EMDR, eye movement desensitization reprocessing, trauma modalities, but in a de facto position in a case that's still de novo, that's young and hasn't been adjudicated yet. So that would be a therapist who is basically possibly violating codes of ethics, 3.04 in the APA Code of Ethics 3.04, first do no harm, but instead of avoiding harm, the therapist is actually introducing harm. Okay. And Dr. Scott Lilienfeld, who was an associate of mine, he passed away a few years ago, from Atlanta, Georgia, from Emory, wrote a really great article, peer-reviewed scientific journal article on exactly that issue. First, do no harm, where well-meaning, well-intentioned, but misguided psychotherapists can be fostering and exacerbating a situation, whether they're using play therapy with a young child, dolls, published drawings, Play-Doh, sand trays, or the other modalities I just mentioned with older children. So, again, there's a lot of paraprofessionals, I call them, involved in these cases, right? You got the CPIs, child protective investigators. You've got the child forensic interviewers. You've got the APRN, Advanced Practical Registered Nurse, used to be called ARNP, Advanced Registered Nurse Practitioner. Now it's called APRN, means the same thing. And or doctor, MD, DO, doing the SANE exam, right? Sexual abuse nurse examination, nurse examiner, a SANE exam, which is the anal genital rape exam, where sometimes they'll use a colposcope to obtain color photographs of the anal genital region that they're examining when they're doing that rape exam. Another paraprofessional or professional involved, and of course therapists. Is another professional that's involved, who is reinforcing the belief system, possibly a false belief system, where false memories could be introduced, right? Implantation of false memories in the minds of the children, based on initial flawed interview protocols, where a well-meaning, well-intentioned but misguided child forensic interviewer is basically culpable of confirmation bias, having a preconceived notion that the child has been a victim of abuse without considering alternative hypotheses. Very, very, very important is the consideration of alternative hypotheses. How else could the child be saying what he or she is saying? Why else Could the child be saying what he or she is saying? Is the interviewer asking open-ended questions that is eliciting free recall, a free narrative from the child without putting words or thoughts or ideas in the child's mind and mouth? So Sally, let's say Sally's the alleged child victim. So Sally, can you tell me what happened? Tell me about that. Tell me more about that. Okay, so with that, those are great open-ended questions. They would be endorsed by the NICHD. And for all of you who don't know, who haven't heard of the NICHD, that is the National Institutes for Child and Health and Human Development out of Bethesda, Maryland. NICHD is our evidence-based best practice methodology here in America. It is endorsed by the Department of Defense, Office of Juvenile Justice, but only about 7 jurisdictions in this country use that protocol or model because it's harder to extract an outcry, a disclosure of assault, sexual or physical, from the child, right? And especially if you have a shy or precocious child. So they would rather use semi-structured models, these interviewers, and most states, like my state of Florida, uses APSAC and radar. APSAC is APSAC. I happen to be a member of APSAC. APSAC.org is their website, and they've been around for a long time. Radar is recognizing abuse disclosures and responding. There's another semi-structured model they're using now in Florida and some other states. And APSAC is the American Professional Society on the Abuse of Children. And so APSAC, if you go to their website, you'll find that they don't require their forensic interviewers to be certified, which I find interesting because so much is hanging in the balance in these cases to try to get truth from falsehood, or did it happen, and did it happen the way the child said it happened, and do you have the right guy, or mistaken identity, the accused, or maybe it happened but you got the wrong guy, and somebody else did it, but that person is not even being considered as a possible suspect or interviewed. And so alternative hypotheses are essential to be adopted and employed by professionals in these cases. That includes your child protective investigator, your child forensic interviewer, your sex crime detective, a police officer who's doing the investigation, who will be there, by the way, at the child forensic interviews. All sex crime detectives attend those interviews. That places the accused, you, under criminal investigation. So if the child implicates you, the accused, during that child forensic interview at the Child Advocacy Center, the CAC, the sex crime detective witnesses that implication. The kid said, Sally said, Daddy touched my pee-pee, put his finger down there and touched me down there. And the detective and the child forensic interviewer and the social worker, the child protective investigator, are all watching this interview. The child forensic interviewer conducting the interview in the child-friendly room, and the child makes a disclosure by from open-ended questions. Then that's probably a reliable and trustworthy statement, an outcry disclosure from the kid, and the detective will go back to the prosecutor and prefer a probable cause arrest affidavit for the arrest of the accused, and charges will be forthcoming either by grand jury indictment or what's called information. So that's how this works, and it's very serious. And you have to have experienced lawyers and professionals who are helping you get through this, because I can tell you this is not a sprint. This is a marathon. I've had cases, some cases have lasted. I have 2 cases still, which I'm on the fringe of consulting on, that are north of 5 years in length of time, and still going on. So make no mistake, the CPS will try to close their case sooner than later to get their confirmed finding, if that's what their mindset is, Usually it is, right? They don't like going out there conducting witch hunts and fishing expeditions, so they want to get something for their time and resources expended, which is a confirmed, substantiated finding. In my state of Florida, it's called verified findings. They're going to want to get that finding sooner than later, and basically ruled on by a judge. Like I said earlier, finding of fact, conclusion of law, with witness testimony from the CPI, from the child protective investigator, perhaps the child forensic interviewer, perhaps even the child's therapist will appear by Zoom or an open court, and they'll get that finding. And I've had a few cases where CPS gets that finding, and that finding is obtained by either preponderance of evidence or clear and convincing evidence. The burdens of proof there are 51% versus 75%, clear and convincing being the 75% burden. So a little higher burden of proof there. Either way, they get that burden, they meet that burden, and the judge rubber stamps and abdicates to CPS's position. Then the criminal prosecutor, if you've been charged, can use that as bait in a plea bargain, right? Can use that as a wedge to force you to plea bargain, meaning, okay, Mr. Jones, we won't send you to prison. We won't convict you of a felony. We won't even make you register as a sex offender, but you'll have to give up your parental rights. We have a substantiated, confirmed finding by both CPS and the court, and therefore we're not going to back off of that one. You got to give up the rights to your kid or kids. And I've had a couple of cases go down like that recently, and I'm not the lawyer, so I'm not even most of the time I'm not even privy to these behind the scenes ex parte plea bargains. I know about this perhaps after the fact, if I know about it at all. And so, you have to get on the same page as your attorneys, and find out in your best interest, how best should you have this resolved? Do you want to go to a trial? And look, I've been to trials in all courts, right? I've testified in front of a dozen juries in criminal cases across this country. I've testified at CPS dependency TPR proceedings at trial. One of my cases was from 5 years ago in Daytona Beach, where DCF spent, oh my gosh, I don't know how many hundreds of thousands of dollars they spent to terminate my client's rights. She was accused of coaching her 4-year-old son, who said, "Daddy put his pee-pee in his butt," and she was accused of coaching. And our position was she was falsely accused of coaching, right? And CPS filed their petition, and that case was litigated in 2019, 5 years ago, and it took 4 months. The trial did. I was there for 1 week in April of 2019, and we won that case. The judge ruled that CPS did not prove their petition, and after it all went down and the judge made her ruling, 2 CPS agents were fired. The attorney for CPS was fired. The regional director for CPS was fired. So there's a lot hanging in the balance here for both sides. Okay, I am from Boston. Obviously, for people who've done the research on me, who know where I'm from, windiness and everything, it's the only thing. And I'm parroting former New England Patriots coach Bill Belichick, but it's true, right? And so I'm not a believer in plea bargains, right? Because I believe if you did it, you should be punished to the fullest extent allowed by law. But if you didn't do it, you should be vindicated and reunify with your children yesterday, right? And get makeup time for that lost time. And so, but I'm not the attorney, right? And so when I get involved in these cases, you have a quarterback, your attorney, and if I come in, the running back. And oftentimes I will score the touchdown as a running back because I'm the guy testifying under oath, not the attorney. So I'm subjected to cross-examination, recross-examination by multiple attorneys, usually in all cases. And you have to have thick skin to do what I do, to do the work that I do, to go up against the government like I do all the time, 24/7, 365. And my position is that there are a lot of children out there who have not been abused, but who are treated as if they have been abused, right? So if you're a non-abused victim of sexual abuse, what are the consequences and ramifications to that child? Well, we see the same signs and symptoms of behaviors in kids who haven't been abused to kids who have been abused. We see psychosomatic issues, headaches and stomach aches and nausea and vomiting. We see nightmares and flashbacks, and we see depression and anxiety, and we see further traumatic regressive behaviors such as suicidal ideations and self-harm. So we see all that, right? And the system, look, this is a very heinous, reprehensible allegation when it happens, right? But it's an allegation, and allegations have to be proved. And your job as the accused with your team is to basically disprove that. If you don't do that, then you will wind up having to come to some resolution which you may not be happy with. And during that process, of course, your children are probably going to be, enmeshed to the wrongful accuser. I'm not going to say false accuser. I'll say wrongful accuser, the alienator. If the allegation was started by the alienator, it's not what you know, it's what you can prove. And so maybe the call came in through a therapist or a medical doctor, and the so-called alienator had nothing to do with it. And he or she is not the source of the child's outcry, but maybe the child, encoded and retrieved that outcry from another source, a book, or a pornographic TV program, or a movie, or an internet website, or another kid at school, or another family member. So there's a lot of kids, a lot of places where kids pick up these things. They are very suggestible. They are very impressionable. These young kids, if they could talk about the Tooth Fairy, Santa Claus, Peter Pan, and Easter Bunny, could talk about how Daddy touched me in bad places. Dr. Stephen Ceci, CECI, did the research on this over 30 years ago. The Suggestibility of the Child Witness, a historical review and synthesis published by the American Psychological Association. Probably won more awards than any other peer-reviewed journal article ever published. Just a very seminal article that Dr. Ceci and Dr. Bruck, Maggie Bruck, his colleague, authored and had published. And, they cited the Robert Kelly case, Edenton Little Rascals, in their work. They followed that up with Jeopardy in the Courtroom, was their huge seminal book published a couple of years later in 1995, again by the American Psychological Association. So you've got to look at the work of Dr. Ceci and Dr. Bruck. You've got to look at the work of my longtime memory associate, Dr. Elizabeth Loftus, Loftus. You'll see both of their testimonial reviews of my book, Elusive Innocence, on the back cover of the same. Dr. Loftus, 50 years ago in 1975, authored, and you'll see this on the internet, on Wikipedia, The Misinformation Effect, and how a child's memory is malleable and can be altered and modified. And, so we have a trigger. We have a trauma-inducing catalyst that can modify and alter that child's memory. In doing so, it can produce and form schemas. Schemas are enzymes or proteins that can modify or alter that child's memory. So instead of there being a direct pathway from the hippocampus, where memory is generated, to the prefrontal cortex, where the narrative comes from, there's a unfortunate collision between the amygdala in the limbic system, which is where emotions are generated, to the hypothalamus, which secretes the number one stress hormone, cortisol. And so when that happens, you can get a implantation of false memories based on the source or origin of where the kid's picking that information up from, and mistaken information articulated by the kid. The system believes, because they're not trained in cognitive development, child psychology, they don't conduct source monitoring, which is vetting, fact checking the allegations. Not doing that, not conducting source monitoring, not fact checking or vetting the allegations, allowing yourself a confirmation biased preconceived notion that because of what the child is saying, you believe the kid, which is usually the case, right? In these child cases with CPS, then that's going to lead to, unfortunately for the accused, faulty information, but substantiated information by the government. And now it's gone up another rung of the ladder. And when that information goes to the court is just going to abdicate or rubber stamp CPS, and the accused is in a huge hole, in quicksand, and quickly sinking. Your chances on appeal, other than appealing the child abuse registry finding, any other appeal, reversing a conviction in criminal court, reversing a termination of parental rights in juvenile court, is going to be, it's going to be like finding a needle in a haystack. Your chances are around 2%, 2 out of 100 in winning on appeal. You're going to be pouring tens of thousands of dollars into an appellate lawyer, who might write a masterful brief, only to have you PCA'd, per curiam affirmed, meaning the appellate court has upheld the trial court against you. And so I don't recommend you go that route. Lawyers that you talk to may have a different opinion on the matter, but I'm just telling you from 30 years of professional experience, and there's nothing I haven't seen in 30 years of doing these cases. Nothing at all that I have never, that I haven't crossed in these cases. I've seen it all. And so, a few things I haven't talked about, said, okay, chapter 8 of my book, Elusive Innocence, sexual allegations and divorce is a very important concept that you and your attorneys should be aware of. You may be on Facebook and getting a boatload of information from fathers' rights groups called the silver bullet, information on the silver bullet. Well, I'm here to tell you there is no silver bullet. Okay, the silver bullet might be something that Dracula, has some connection to, right? But in these false or mistaken, misinformation, source misattribution, error, child abuse cases, there is no silver bullet. There's no empirical literature ever published on the silver bullet. There is no scientific information that basically connects to the silver bullet. Now, said is a different story. Sexual allegations of divorce was first authored by Blush and Ross back in 1987, and it was basically it was basically the data were verified by multiple experts over multiple time frames. Traumatizing and Bala from Canada, Dr. McKay from the UK. And of course, I excerpted this in my book. And anecdotally, of course, I have a huge amount of data that would support probably a published scientific journal article on a study where I would obtain statistical clinical significance based on the anecdotal data that I've assimilated over the past 30 years in said cases. Said cases can occur within the midst of a divorce, the midst of a custody battle, in the midst of a parenting time dispute, where the accuser is trying to obtain equity at law in court, wielding the child as a pawn, weapon, or tool to do the same. And usually you see the allegation surface a few weeks before a court hearing. Oftentimes that allegation may be used with a younger child, 4, 5, or 6, preschool or even early school years, 7, second grade, where the child's at the psychological age of reason. But for the most part, the factors are there that would indicate that this may be a said case and a wrongful allegation of child sexual assault. Now, Dr. Burnett, William Burnett, who of course is just a iconic figure in parental alienation, and oftentimes speaks webinars, publishes academic books and peer-reviewed journal articles. And certainly I've referenced his work several times, and I'm going to reference it here again with his authorship of the 5-factor model for parental alienation in 2020, and how important that model is. He and I worked a case together from his home state of Tennessee that we were successful in the latter part of 2022. And that 5-factor model, the 5 factors are basically the first factor is the child has gone from resisting to disconnecting to rejecting the targeted parent, you, the accused, has basically built a enmeshment with the accuser, the alienator, and lost emotional attachment with the accused, the targeted parent. The second factor is that the accused, the targeted parent, can furnish for the court audio, video, pictures, photographs of basically where at one time the targeted parent had a positive, normal relationship with that child. The third factor are the false allegations, the unfounded or unsubstantiated allegations that never preponderated in court, that were meritless, were baseless, that never basically rose to a preponderance of evidence. And that's factor number 3, are CPS, unsubstantiated allegations of abuse and neglect. And factor 4 and 5, we have the signs, symptoms, and behaviors are consistent with an alienated child, and signs, symptoms, and behaviors are consistent with an alienated parent. So, which is going to dovetail my talk into what's called a motion for IME. A motion for IME is a pleading filed by counsel, oftentimes in family court cases, asking the court to order a independent medical or psychiatric examination of the accusing parent, the falsely accusing or wrongly accusing parent. And the lawyer must lay foundation or predicate in order to do so, to have the court even give that pleading consideration to be granted. I had a case you all may be privy to. I was retained in where my client, John Mast from North Dakota, was brutally and tragically murdered February 5th of 2021. And it was a case where I testified for him in May of 2020 by Zoom. John was accused of sexual abuse of both his children, his son and his daughter. He was accused of raping his wife. He was accused of physical abuse and domestic violence at a restaurant, all of which was disproved. And finally, the court in December of 2020 ruled that John was innocent and was never arrested or prosecuted, but the court made that ruling in family court. And that he would be able to reunify with his children, who the mother took to Idaho, Lewiston, Idaho. And unfortunately, when John showed up February 5th of 2021 to see his kids for the first time in 3 years, he was met by the maternal grandfather with a 9mm handgun and took 3 bullets, which killed him at the scene outside a grocery store. And so And this is how volatile these cases can be. Right, there's a lot hanging in the balance here. I am just I'm still emotional about John's case, and for his kids, but you know, mistakes cannot be made in these cases, right? And so it's very important that the lawyer, the expert, the accused have multiple powwows over time, if necessary, by Zoom or by phone, to get on the right track, make sure legal theory and strategy is correct and effectuated in court. The alleged facts and science and law must all intersect in court in order for you to prevail. Very, very, very important. The last thing I'm going to just briefly hit on is and of course, what I'm known for in my cases is the psychological, psychosexual testing of the client, right? The accused. And so this is talked about at my website. I highlight this in my book, Elusive Innocence. The gold standard child sex tests we still use, the ABLE screen, ABEL screen, or ABLE assessment for sexual interest. Number three is the high conflict test, ABLE screen test that we use, AASI number 3. The website is ablescreening.com, ABEL screening.com. And so we're looking to see, because the test gauges your level of sexual interest or arousal in prepubescent children or pubescent children, whatever the age group of the child who's accusing you of is. So we're looking to see your sexual interest or arousal to children versus consensual relations with adult women. And I say that I'm targeting men here because usually it's the men or fathers or stepfathers or uncles or grandfathers who are the accused recipients of these sex abuse cases from children. But the other thing you have to look at is called cognitive distortions, and whether the accused is trying to justify his abuse and try to be a con man or hoodwink himself, his lawyer, me, the expert, the child who's accusing him, the entire system. Some do. So we're looking for a result on the CD scale score, which is written part of the ABLE testing, ABLE questionnaire for men. We're looking to see that the CD scale score, cognitive distortion scale score, is less than 25%, would be normal. I've had some clients that have blown it 60, 70%. And we know that when the child said, he told me to keep this a secret, don't tell anybody, that the child was correct. And of course, the same client also showed sexual interest to kids, to children. So we know sexual interest precedes the act of sexual assault. And I authored a paper on this that was published way back in 2007 on this very topic. That's about all I have. Like I said, it's been an honor and a privilege to present here for Elaine and her group. Hopefully you all have learned a few things from me and can take them back to use them yourself as pro se litigants in court, or better, to your attorneys to help you clear your names and reunify you with your kids. I want to thank again Families Divided TV, Family Access, Fighting for Children's Rights .com, and I will see you on October 5th, 2024, exactly 1 month before the election. Thank you.